afternoon and welcome to this, our first residential property forum for Scotland for 2025. We've been really excited and pleased with the support you've given the forums in 2024 and hope to build on that this year. Again, we're led by Ian Quayle, who will be discussing some topics of interest, some points you've raised since the last forum, but most importantly, it's your contributions that make this forum so good. So please, if you have any comments, put them into the chat box or raise your hand. We'll try and then unmute you. But the idea is that your knowledge combined with Ian's creates a massive resource for lawyers, and really it's a chance to tap into that. So less from me, Ian, over to you, and let's get started.
Fantastic. Thanks, Robert, and good afternoon to everyone. Thanks for coming along today. Yeah, those of you that this is your first attendance, the idea of this forum is to enable residential conveyancers to sort of meet virtually and discuss any issues that are pertinent to the work that you do. So it could be an issue with regard to title, it could be an issue with regard to documentation or procedure, it could be a request or a discussion about product. So I can recall that one of the forums we did very early on, there was a discussion about various different search companies and all manner of different things in connection with software and case management systems. So it can be anything, in short. My job is simply to sort of start the ball rolling and to push, if anyone has any sort of burning issues, to push those issues to the room, to the virtual room, as it were, to also have a think about topics for the future and indeed speakers for the future. We've got a number of very interesting people that are going to come along in the future to talk to the forum about their expertise and about their knowledge. We do record today's webinar. It will last approximately 60 minutes. If there are any sort of burning questions that arise during your practice in between each forum, send me an email or send Robert an email, and we'll gladly sort of ensure that that topic is raised at the next meeting. If it's something that's urgent or something that I can deal with in the intervening period, I will do so. A massive, massive thank you to Stewart Title. I can't tell you how supportive Stewart Title are for the legal profession throughout the United Kingdom, to be honest with you, looking at the provision of a great service and great products, of course, but secondly, supporting events such as this and allowing events such as this to take place. Without Stewart Title's involvement, these sorts of things just couldn't happen. So a massive thank you to Stewart Title for the sort of setting up and doing the groundwork with regard to these events. Robert Kelly from Stewart Title is Commercial Business Development Manager, I think, for the United Kingdom. We've got John and we've got Liz, who are both managers and part of the development team for Scotland, all of whom are happy to come along and talk to you about product, about your requirements for product, about compliance issues, etc. So a fantastic resource. Yes, there's an online presence. Yes, there are online products. But from time to time, I'm sure you'll encounter something that's unusual or something that doesn't quite fit the standard online product. And there's a team there waiting to help and to assist. On the compliance front, there are some really interesting issues relating to compliance and defective title insurance that a lot of practitioners aren't in fact aware of. And I know that John and Liz and Robert are more than happy to sort of walk you through some of the compliance issues that are significant. Before we finish today, I'm going to talk to Robert a little bit about some of the things and some of the developments that Stewart Title have planned for 2025, because there's some interesting things there. But Robert, Liz and John are in the background here. If you have any questions or issues, there's a chat facility. You can raise the issue or raise questions in there, and John, Liz and Robert, I'm sure, will pick them up as we progress during the course of the next hour or so. So Stewart Title, details there about product, etc. As far as contact details are concerned, worth taking a photograph of that slide. If anyone wants copies of the slides or indeed a copy of the recording for today's webinar, that will be made available to you at the end of this event. So they're the contact details for John and Elizabeth, who are the points of contact for Scotland, and my details are contained on that slide too. Make a note of that if you need to contact me. So, topics today. The first thing I want to talk about is climate change reports and the availability of climate change reports. Why, might you ask, am I remotely interested in climate change reports? Because the Law Society of England and Wales is about to issue new guidance to the profession in those two countries on climate change. And again, firms are getting worried about the potential for liability for the firm with regard to a failure to give advice concerning climate change, and just what should firms be doing? Well, the first thing is there isn't an equivalent guidance as yet for Scotland, but I do think it's important from a potential claim perspective that you understand what's happening in England and Wales, and you also appreciate, I think, the fact that it's not a sort of terrifying area that you need to worry yourselves with, because in essence, all that I think is necessary for a conveyancer to do is simply to advise clients who are purchasing property that it is possible to obtain a climate change report, and that climate change report will identify potential risk relating to that dwelling or property, and also will give advice generally to property owners about risks associated with climate change, divided into three main areas: risk of physical damage to the property that's being acquired, something called transitional risk, risk of government legislation or regulation being imposed on property owners that either impacts on marketability, impacts on value, or impacts on occupation. So there could be regulation or legislation about electric vehicle charging points, about heat source pumps, about energy efficiency, etc. And all of that could be simply recommendation, it could be imposed on property owners. Either way, it will have an impact on property ownership. So be alive to that, be aware of it. First question to the room this afternoon: anyone currently advising a buyer that it is possible to get a climate change report on a property? Hopefully no one is saying in their retainer or engagement letter that we'll give advice on it, because you can't really. It would be a crazy thing to do unless you were particularly comfortable or you had an environmental team that was comfortable in doing so. Anyone got any views on that? Any comments on that? Nothing in the chat boxes yet on that. So I'm going to move on and talk about the property standardization group. This is something I was looking at over the holiday period. It shows you how sad I am, really, doesn't it? But there you go. Anyone had any word or any dealings with the property standardization group? And my first question, is it still active? Anyone know? Anyone deal with it? Anyone use it and use their precedents? And what I found was a letter to factor or property manager in the event of a sale of a property, again asking for information, etc. And I thought, well, that's quite a useful standard letter to go out on a sale. Anyone any comment or any views about that? Use the templates. Thanks, Alison. So Alison is, thanks for the response. Is it still active, the group? So are they looking at sort of developments and things, Karen and Alison? And as far as the templates are concerned, do you find them really useful? Have you had to modify them? Do you use them as standard across the board? I'm interested in their sort of flexibility in their use generally. Diane, hi Dan, hi Debbie. Right, yes, you use them. Right, okay. They're updated regularly. Oh, thanks for that, Jerry, and often used. Okay. Anyone not using them? Anybody not using them? To be honest, I think it's a great idea. You know, the more standardization there is, the more helpful it is. The only thing I would say about template standardization of process, standardization of documentation, is there is a need to be careful on the basis that all clients are individuals, and therefore we need to personalize what we're doing. Yeah, Jonathan, when you say a point of reference and templates, they are that, aren't they? Okay, you know, they're not sort of something off the shelf that we just throw out every time. We do need to think about their use, but that's really interesting. And thanks, Karen. Observations, property standardization group style for factors. It's used, yeah. Okay, and does anyone amend, or has anyone got any sort of areas where they think that you know there's additional questions or additional information that could be sought, or does anyone sort of personalize or include additional standard phrases, terminology, questions, etc. in any of the documents? Because I did an exercise a couple of years ago, well, 4 or 5 years ago actually, where there was a standard document that was published by, I think it was the RICS, Royal Institute of Chartered Surveyors, and they had a standard document, but there were issues that practitioners were saying, well, you know, we amend it, and you know, lots of firms were saying, well, we use it as a template, but there's things that we insert there that we think are necessary. So am I fair to think, everybody, that there isn't anything sort of lacking in any of this, the precedents that you're using? And all right, there might be a need for additional stuff. Yeah, thanks for that, John. Is that there might be a need for additional stuff depending on client, depending on transaction, depending on property, but the framework is used and it's active, which is the other point. So thanks everybody for that. That's great. Okay, what about the standard clauses edition 6? Is there anything in there that's radically different? I've just started trawling through it, to be honest with you. And I was interested to see, has anyone else had a look at the standard clauses, looked at the guidance for clients, guidance for practitioner, checklist, etc., and anyone that got any comment on it and any views? Again, interesting stuff, to be honest with you. But whenever anything new is introduced, there's 2 or 3 things that worry me. Number one, some firms aren't aware of the changes. 2, some firms take time to incorporate changes, etc. John, I noticed you had your hand up there. Hi, John.
Yeah,
put your microphone on.
all I'd say there is, from our point of view, Ian, there is a specific section on title indemnity policies within new standard condition 6.
Yeah.
So bear that in mind, and I would be interested to see what everybody said as a response to that, because there are conditions that make it almost proactive if there's an existing policy, and we don't really get many people inquiring about the continued validity, for example, of existing policies. So title indemnity is one of the things that's covered in there, so you might want to have a wee look at that specifically.
I will. So John, are you saying, right? I just want to deal with John's point, then I'll come back to you, Cheryl. But that's interesting. So, John, are you saying that obviously there's been an issue with existing policies and transmission of existing policies on acquisition of a property?
Well, I don't know exactly whether there's been an issue, Ian, but there is a specific section on title indemnity. I think it's section 36 in the new standard missives. I presume it was in all the previous ones, but we never ever get any sort of feedback from that. We never get people. That's not true. We occasionally get people coming and saying, "Is this policy still valid?" And a lot of that's not within our knowledge, because the validity of the policy depends on what the people who are selling the property can confirm.
Yeah. Because certainly I've seen situations where if there's an existing policy and I'm acting for a buyer, I either want warranties from the seller as to the existence of the policy and their knowledge with regard to the risks associated with the policy, or I'll perform a due diligence exercise of the insurer, John, in making inquiry of you to confirm, A, is the policy still in existence? B, has the premium been paid? C, have you received any form of notification, which would be an indication of claim, etc., etc.
But we can only confirm what's within our knowledge, and so we can only confirm if we know there's a claim. Obviously, we can't confirm, for example, that the terms of the policy have been complied with. That would really need to be for the seller to confirm that. All we can really confirm is our knowledge of whether there is an ongoing claim or otherwise. There's really little else that we would know about. So just so that everybody sort of knows that's where we are. You've got to bear in mind that we don't have knowledge of whether the seller has complied with the terms of the policy. That's for the seller to confirm.
I'm just trying to dig that out at the moment. I'm just going to have a look at it and see what it's.
I think I've got them here somewhere in my drawer.
All right.
I did have them because I actually downloaded them, but I might have placed them somewhere else because I was dealing with other things.
Okay, no problem, John.
No, I don't seem to have them. They must be somewhere else. Right. But as I say, that was one of the things that jumped out at me.
Right.
The fact that title indemnity is now. Oh wait a minute, I've got them here.
Yeah.
Yep. Section 36, I think it is. 38.
Yeah.
Or 35, and there's a big section on title indemnity policies.
Right. Okay. Well, I think what we should do in the next forum, we should have a drill down on that and have a look at it, a long, hard look at it, John, because it sounds interesting. Thanks, Ian, by the way. Yeah, 35.2, something we need to look at. Great. I've got lots of stuff in the chat that I want to have a look at, but thanks for that, John. Really interesting. Cheryl, hi, Cheryl. Condition 4, no warranty reappliances now. Diminishing limit now £500. So there are a few changes. So thanks for that, Cheryl. So is everyone aware of them? And again, when you're reporting to client, etc., are you making sure that your documentation has been amended so that you're consistent with what the clauses now provide for? Okay, infestation definition expanded. Yeah, is that because of the Japanese knotweed stuff, Cheryl? And overseas entities, okay, now provided for at condition 36. All right, yeah, great. Okay, Diane, hi, Diane. Condition 34.3 still relates to earlier sales, which is still required to amend. Okay, everyone got that point that Diane made. So there's quite a lot there. What I'm going to do is take a picture of that, and I'm going to have a look at that. Right, so some people are still using edition 5, Francis. Okay, that's interesting too. So I'm just going to, as I say, take a picture. So I've got these points, and we'll have a look at overseas entities. Infestation of insect and animals now, okay, because there's a thing in London, wasn't there, about, was it moths or something? Infestation of moths in a really expensive property and all that, yeah. And what is an infestation? Really interesting stuff, isn't it? I haven't seen that. I'm sure that matter in London has gone to court, but I haven't seen a judgment or anything. I'm assuming it's still sort of still proceeding, but I don't know anything about it. Right, let me take a picture of this, and then I've got it for the future, and we'll deal with those issues next time. Interesting. Okay, right. So the next thing that I've got on my list is assessing risk in conveyancing transactions. And again, I think this is something that is so important. I was talking to one of the big insurance brokers, not Marsh, the other one, about risk in conveyancing transactions in Scotland, Northern Ireland, and England. And again, the same sorts of things were coming out to me. You all are, I hope, are aware of the risk management materials that are available on Marsh's website for Scottish solicitors. All got that? Self-assessment questions, etc. Focusing on risk in property conveyancing practice. Don't know if you saw the data from one of the insurers and from Marsh about the high proportion of negligence claims arising in conveyancing. Also, I tell you what was interesting. Again, there was an article that I was reading somewhere about in commercial transactions, break clauses are still causing problems and still causing claims. That again is sort of a nationwide issue, to be honest with you. Right. So what about lender claims? Again, where you find recession, where you find lenders repossessing properties, you see an immediate correlation with regard to claims against conveyancers. So do have a look at lender handbook requirements. And again, something was put to me recently about this. Reporting to a lender. Invariably, when you report to a lender about anything associated with title, lenders in essence say, well, we're going to rely on your professional opinion or your view. In other words, in code, we're going to rely on your professional indemnity insurance policy. So there was a firm I was talking to who was saying, well, we're not going to, we've given up, we've abandoned reporting to lenders on issues that we think are issues of risk, on the basis that the lender's just going to fire it back to us and say, well, it's down to you, sort of thing. And I was talking to a barrister about this, and he said, no, always, if you're acting for a lender, report an issue, even where the lender is going to say, thanks very much, but if you're happy, we're happy. As long as, if you're getting that sort of response, the danger is you think there's no point providing the notification about the issue, about the problem. You always report it, even where the lender just comes back and says, hey, it's down to you. Important. Right. There is, of course, a feeling now that there's going to be a relaxation of lender requirement. And the view from insurers is, the view from Marsh is, that relaxation could lead to, again, an overheating of the market, a rapid cooling of the market, lots of borrower default, lots of lender repossession, lenders taking hits with regard to valuation and proceeds of sale, and then looking at conveyancers and solicitors to recover that loss. So again, just be careful. The next point is that, again, with regard to lenders, it's important that you are familiar with the fact that lenders will quite frequently change their requirements, reporting requirements, requirements with regard to title, etc. So it's essential that all your colleagues, everyone in the firm, now ensures that they check lender instruction, not just at the start of the transaction, but before concluding missives, etc. Just checking that everything is in good order. Okay, you can use checklists with regard to lenders, you can use case management systems, etc. But the important point is that you're undertaking a risk assessment with regard to lender instructions, just as you would with a lay client. Again, the other point that is of concern to insurers at the moment, frauds and scams. Again, fraud and scams, seller identity fraud issues, email issues, banking information issues, again, still causing problems and still causing issues. So again, the point here that insurers are making, Marsh make, is the fact that you've got to make sure that someone in the firm is being aware of developments, of changes, of standards, of guidance notes, bulletins, risk alerts that are coming from the profession and coming from elsewhere. Marsh undertake training on frauds and scams. Everyone's seen that. Anyone undertaken that? So there is and I thought that Marsh training was free. Can anyone help on that? Has anyone attended, or I don't know if it's virtual or face-to-face, the Marsh training on frauds and scams? Cheryl, is that a yes to that, or is that a yes to the infestation, insect and animal thing that we mentioned earlier? Anybody? So Marsh training on fraud and scams. Again, have we undertaken it? Do we have colleagues that are undertaking it? Someone was raising a really interesting question this morning about the use of locums. And, if you have policies and procedures, if someone's coming into the office, or you've got staff sort of covering holidays or sickness, etc., are they aware of your procedures and processes? Have they undergone the training that others have? Or if they haven't, is there some form of supervisory system or process that means that the work that they're doing is checked by someone that has undertaken it? I saw a locum, I think it was on LinkedIn last night, and they were saying one of their problems that they have now is that when they're going into firms to cover holidays and illness, etc., is firms are using case management systems, and the locum, or the member of staff coming in on a temporary basis, isn't familiar with the case management system and is taking time to come up to speed. And the other thing that's interesting in that, and I've just seen this as well, some firms have case management systems, and the head of department or the partner in charge will say, well, that's the system we use. And then actually when you start getting embedded within the firm, you find that fee earners, individual conveyancers and solicitors in the firm are using a sort of variation of it, or doing a workaround on the basis that there are some issues or problems with regard to case management systems. We need to be aware of that as well. We've talked about external frauds and scams. Again, if you are checking and seeing what's out there with regard to potential claims, etc., is that being distributed amongst all members of the team? Right. Assessing risk with regard to transactions. Interesting. Do you actually, when a set of instructions come in, assess risk and make sure that that file or that transaction is distributed to a fee earner that is capable of dealing with the risks or the issues relating to the transaction? I've seen some systems where there's like an onboarding process in which there's an assessment of the proposed transaction, and it sort of indicates levels of risk. Don't know if you've seen that in Scotland. I've seen it in England, haven't seen it in Northern Ireland, but I guess the same sort of software would transmit from one system to another. But has anyone seen that? So the idea is, instead of you or whoever's dealing with new work that comes in, assessing the file and assessing risk, the sort of software that does it for you. Anyone seen that or heard about it? Might be worth getting a software company to attend one of the forums to have a look at that for you, because it is quite interesting and very useful, certainly. Next thing, this really gets my goat, to be honest with you, for conveyancers. Attendance notes, lack of attendance notes, lack of notes in connection with telephone calls, etc. I think the hardest thing for a busy conveyancer is to attempt to comply with the requirement of insurers and indeed professional bodies to make full and detailed notes of attendance. And again, the important point here is that it's not just a question of making a note that Mr. and Mrs. Carruthers have been in to see us, but making a note of what Mr. and Mrs. Carruthers have been in to see us about, what we've discussed, what issues there are, what advice we've given. So, you know, highly dangerous. Is anyone now recording or using software to record an attendance or using AI for that purpose? Anybody? I think it's got to be the way forward, and I think that it's got to be the way firms will have to go in order to, because there's a sort of mismatch, isn't there? I think that if you're really busy, there's no way you can make a full and detailed attendance note in connection with every client about every issue. What you tend to do is highlight key issues or refer to an email or a letter that's sent to the client thereafter, or some firms will have a checklist and highlight a pen and yes, I've discussed that, yes, I've discussed that, yes, I've discussed that. Well, again, all of that is helpful, but is not really what insurers are asking for. So again, you know, a file note to support solicitors' recollections is a real tool for an insurer in defeating or defending claims. So again, do you audit attendance notes? Do you review your attendance notes? I know some firms over the years that have actually have attendances dictated or the notes dictated, and then someone typing them out and put them on file or put them on the case management system. Again, important. Absence of a file note, difficult to defend a claim, difficult to argue that what a client is saying is not correct. So again, important as far as that's concerned. So again, I asked the question, Cheryl, Francis, Diane, Ian, anyone using AI or using a recording system to record an attendance with a client, personal attendance, virtual attendance, telephone call? Now, it might be that you do that if there's a particularly important issue to discuss, particularly where clients, are hell bent on proceeding, and you're saying, steady, there's some issues here that we need to look at. Or the client is saying, well, I'm prepared to take a view. So you're recording calls, Alison, yeah. But what about an attendance? I mean, I guess some clients would be pretty uncomfortable about recording an attendance and might be unhappy about it. And again, it's a bit awful saying, well, the reason I'm recording it is in case there's a problem in the future. I get all that. I can see resistance and pushback to it. Yeah, handwritten notes made during calls, etc. Yeah, Francis. Okay. I tell you what I had years ago. I had a client who couldn't read. Very successful businessman, couldn't read. Okay. And we used to do loads and loads of work for this guy, all sorts of stuff. Some fairly big deals with him. And again, what was the point in sending a report to him or an email or a letter to him following an attendance? What was the point? Was the view. So has anyone ever had that? Or clients where English is not their natural sort of language, etc., and is a second language? How do you deal with these sorts of things? It's tricky, isn't it? Yeah, type for the file, Eleanor. That's the safe way. Has anyone ever sent an attendance note to a client to say, we've just had a meeting about this, you want me to do X, I've advised that you should be doing Y, I'm happy to act for you, but there's risk involved in the course of action that you're suggesting. I want you to sign a copy of this note or this attendance note, the note I've made with regard to a telephone call, to indicate this is a true record of what we've discussed. Anyone ever done that? Again, I think where a client is saying, asking you to proceed and you've advocated it's not safe to proceed, or you've highlighted an issue to the client and you're of the view that you don't think the client really gets what you're saying, I think it's important. Ian, I'm delighted to say that us Ians are sticking together. Yeah, I think it's important to do it. And ask the client to sign it and say that's a true record. Or say to the client, look, if you don't think it is a true record, tell me how it should be altered, etc. Yeah, I think it's so important, isn't it? Highlighting issues, Debbie, and then confirming advice. Yeah. And I tell you what else is interesting, isn't it? Thanks, Francis. Thanks, Diane. I tell you what's else interesting, right? So we talked about this last week. We are, unfortunately, as property lawyers, in a very difficult position because it's very hard to disengage ourselves, isn't it? In other types of work, you know, litigation, etc., if the client's not heeding our advice or the client's asking us to do something that's crazy and is doomed to failure, we can extract ourselves, can't we? But in conveyancing, it's quite difficult, isn't it? You know, I've seen over the years complaints to the Scottish Ombudsman, English Ombudsman, where a firm has said, look, I can't act for you anymore in a conveyancing transaction. And that's led to a complaint on the basis that, you know, you're leaving me midway through a conveyancing transaction, meaning I'm going to have to instruct someone else to start all over again. So it's tricky. I think particularly for junior members of the team, making sure that they're making proper records is important. Eleanor, yeah, you don't think you need to have, I agree, not everything signed. But if the problem I would have, Eleanor, with just sending an email to the client is the client then saying, well, yeah, I got the email, but I didn't understand it. Or I got an email confirming what was said in the meeting, but that's not what was said. You know, it's that sort of thing. Now, Eleanor, just so that we're quite clear, I'm not saying you do it all the time. I'm saying if there is an issue that I think could potentially come back and bite me, I would do it. Okay, because I've seen over the years, clients have really selective memories, haven't they? You know, like with defective title insurance, as John was saying earlier, the client loves the fact that you've found a solution to the problem and the home of their dreams is now likely to be a reality. They don't get the fact that the problem, the risk with regard to the defect in title still exists. Ian, right, note 16, Thompson and Warwick, yeah. Yeah, well, there's loads of them, isn't there, Ian, where, you know, the insurers and the courts are saying, well, you're a professional person, the client, and you have loads of transactions active at this particular point in time. The client only has one transaction. It's no good as a lawyer saying, well, this is what I usually do. Prove to us this is what you actually did. I've seen that before. You know, it's all well and good. Yeah, well, I have a checklist and I've marked off the checklist that I discussed that with the client. Well, the fact that you marked it off on the checklist isn't evidence that you discussed it with the client, particularly where the client is saying that's not what was said or that point wasn't raised. Yeah, I think what I'll do, I might dig out the judgment on that case, Thompson and what I've read it before, Ian, but it is useful, isn't it, as a useful reminder. The problem sometimes is that sheriffs, you know, don't get the work that you're doing, don't understand how busy it is, etc., doesn't understand how demanding clients are. And of course, in the context of conveyancing, you know, there's a base level of service that's accepted, no matter how busy you are, no matter how little or much you're charging. Interesting point. I saw an English case where, for once, the judge said the fact that the firm was charging a relatively low fee, the fact that the client had found this firm out on the basis that they were renowned for charging low fees, the level of service that that the client could expect would be less than a reasonable standard of service. The reason that the judge made that finding was that in the retainer letter or engagement letter from the firm explained that the firm would be providing a basic service, explained exactly what the basic service was, and explained that the basic service wasn't the same as their normal standard service, and that there were omissions and things that wouldn't be done in connection with the basic service that would be available to the client who chose a standard service at a higher fee. So I think for once I've seen a court say, yeah, the issue of how much you charge is an issue with regard to the level or standard of the duty of care that's owed to the client if we're talking about a delict claim. Okay, so we've covered that off. Let's have a look at some other risks with regard to claims. Again, reviewing files as the transaction progresses, assessing risk as the transaction progresses. So it's not just a tick box exercise, right? We've done that, that's fine. It's a question of constantly reviewing the file and assessing issues. Really interesting point that I had a discussion about last week with someone. Fees, okay? In what circumstances, if you're proceeding on the basis of a standard fee or a fixed fee for a conveyancing sale or purchase, in what circumstances could you charge the client more for the work that you're doing? So in your engagement letter, do you say to the client, look, we've given a quotation or an estimate with regard to our fees. We reserve the right to review that estimate or charge on the basis that the transaction may be out of the norm. I think you're perfectly entitled to do that. And I think it's useful to say to the client, here are examples of circumstances where additional work would be required from us, for which additional charges would be levied. Or how many people will just give an estimate or a quotation to a client and just stick with it through hell and high water? What are our views on that? I mean, there's case law I can point you to where the courts have said in the past that if you give an estimate or quotation to a client at the start of the transaction, you've got to adhere to that quotation or estimate unless there's an objectively valid reason for revision upwards. And if there is a need to revise upward, A, the client must be notified of the circumstances, B, notified as to what the revised fee will be, and given the choice to either withdraw from the transaction or to proceed on that basis. Interesting in what everyone's views are on that. Diane, Eleanor, Jonathan, Ian, anybody else? Neil, anybody? It's an interesting one, isn't it, with regard to fees? You can't give a cheap quotation, cheap estimate, and then bang on loads of additions just as a matter of course. You're not allowed to do that. But you can, if the transaction isn't as you envisaged, isn't as a standard transaction, you can charge more. But you've got to make sure that your client is aware of what you're doing before you do it. So can I ask a poll of everyone attending today, who, if they gave a quotation or estimate, would just stick with it? And who has a system whereby they would charge more? Yeah, that's great. Diane, do you give examples of where a transaction wouldn't be seen as standard? And the important thing, and I'm sure Diane adopts this, yeah, exactly. But the important thing is to let the client know as soon as possible when additional work is necessary. And Eleanor, you make a good point there. But what I would always do is, even if I wasn't going to charge the client, I would let the client know that I'm doing additional work and I'm not charging for it. Yeah, exactly, Karen. Yeah. Because I think in doing that, at least you're generating goodwill, aren't you? I have seen nightmares. Yeah, exactly, Jonathan. I have seen nightmares where a client, well, let's put it this way. Let's have a look at it, right? Transaction starts, quotation provided to the client. Transaction progresses, definitely more complicated than the Fiona envisaged when the client was onboarded, okay? Client made aware of additional work that was being done, but not advised during the life of the transaction that additional costs were being incurred. Okay. At the end of the transaction, client sent a bill, not for the original quotation or estimate, but for the original quotation and estimate, plus the additional work. Surprise, surprise, client bleats. And again, the point there is that, although justified on the basis that you've done loads of work, is not good practice. Important that client is aware that you're doing work before you do it, is aware that there's a cost implication of what's being done, and is aware of the additional charge that is going to be levied. If you're not doing it, like Ellen and I were just saying a little earlier, at least let the client know that you're doing the additional work, particularly where the work is going to involve perhaps a delay or the transaction going to be sort of elongated, as it were, due to the work that is being done. I think that's so important. Effective communication with clients is critical, isn't it, throughout the transaction? Anyone got any burning topics then? There's some of the topics I've mentioned. I'm going to talk about payment diversion fraud before we finish. I've got some other things that sort of back up to talk about too. But anyone else got anything that's sort of causing real problems at the moment? Or issues at the moment? A real bugbear that I talk to people about at the moment is delays with searches, getting searches back, etc. How are you managing with that? Talked to someone last week who was saying, I forget which search it was, it taking 10 weeks for a search to come in. Not a problem, it seems. Or is it a problem? I don't know. Yes, quick. Okay, that's good, isn't it? So yeah, but it does cause delays in concluding missives. Yeah. I tell you what, that's really interesting, right? My experience with search companies in Scotland is they're impressive. Yeah. PSS, yeah. Yeah. In England, there's a whole spectrum, a vast number of search providers, and they go from competent and fast to I wouldn't dare say incompetent, but slow. Okay, and again, yeah, in Scotland, I don't seem to get the sort of negative feedback that I get. So PSS getting really positive recommendations here. Okay. And is it just because of speed, Cheryl, Eleanor, Karen? Yeah, Miller and Bryce, Diane, I know them. Yeah, they're great. As I say, I couldn't pick between them. Everyone that I've spoken to and everyone I've dealt with, yeah. And I've met with First Scottish, Lindsay. I like them all, to be honest with you. They seem to be on the ball. They seem to know what they're doing. And I think the other thing is, yeah. Thanks for that, Francis. The interesting thing is, I think that it's not necessarily the search companies are different. I think the source of data in Scotland is better. Are you with me? The message, the information, the data that then gets to the search company, that seems to be quick, and therefore the search companies are quick and very efficient. Very good. Okay. Are any of the search companies saying, look, we can do more other than searches? I mean, that's the big thing in England and Wales at the moment. We're not a search company at the moment. We're not a search company anymore. We're going to do this, we're going to do that, we're going to do the other. We've got case management systems, we've got information recording systems, we've got, everything and everything. I'm a great believer. Insolvency checks, yeah. Yeah, that seems to be the thing, Karen. And again, I mean, in some respects, I think it's a good thing. The only thing I would say, and I just had a meeting with a search company recently that Robert Kelly and I know, and I was saying the big thing that I see when I talk to firms and solicitors about search companies is, yes, firms are really interested in all the add-on services, but what they don't like is the idea, well, you can only use that product if we buy our searches. What people like is the ability of a company to integrate with their existing search provider, no matter who that is. And I think that's so important. And I think integration generally is important, given all of these things that are now coming along to assist us, money laundering checks, client electronic verification checks, etc. Is there any appetite for electronic signatures? Because that's again in commercial work generally, commercial property work generally, electronic signatures are a big thing, and you're seeing more and more in England and Wales the use of electronic signatures generally. Yeah, okay. And is there software that you can buy into, Debbie, for that? So it's interesting times, isn't it? Anybody using AI at all at the moment for reports? As we were saying earlier, for sort of, DocuSign is the thing to use, Debbie. For preparing reports, etc. Anyone using artificial intelligence? You can see it happening, can't you? You can see what's coming down the line, can't you? And I think all of this use of software case management systems is great, as long as we don't forget, at the end of the day, we're conveyancers, we're specialists, we've got expertise, and no matter how much technology is sitting behind us, we've still got judgment calls to make on a fairly frequent basis. It's like what we were saying earlier at the start, wasn't it, about the precedents and standardization. Templates, etc., are really useful. We still have to have input, we still have to look at what they're doing, etc. But as a framework, I think they're really useful. I've talked to a guy who's probably more of a dinosaur than me, to be honest with you. And he was saying that, because I expected him to say, Ian, don't talk rubbish. I'm not going to use case management systems. I'm not using onboarding systems, anything like that. I've been a solicitor conveyancer for donkey's years. I know what I'm doing, and therefore I'm not doing it. Interesting. He said, yeah, I've got a case management system. I've got a means of electronic reports to clients, etc. And the reason I do that is, yes, I'm very experienced. Yes, I think I know what I'm doing, but I still can make mistakes. And therefore, if I've got a template, if I've got systems and processes sitting behind me, the chances of my making a mistake are reduced significantly. I think that's a good point. Right. So, Debbie, DocuSign for internal meeting notes, and you're happy with it. Yeah. Okay. Does that sit, Debbie, with your case management system, etc., and all your other? No, it doesn't. Right. Okay. Yeah. Oh, AI for minutes. Yeah. 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 We're starting to use it. We're starting to use it. It's good. It's interesting. It frees up time, doesn't it? It gives us time to do the sort of tricky things, is the way I look at it, Debbie. Yeah. Okay. And Karen, PSS, your anti-money laundering checks, etc. I'm assuming it's client identification verification as well. Are they progressing into it or now offering it? So is it something they're talking about or actually doing? Yeah, action points for that's good, isn't it, for our AI as well? Yeah. Really clever, isn't it? Really clever. It's amazing what technology can do. Scary, but at the end of the day, people say to me, can you ever see a situation where, conveyances are made redundant? Well, the answer is perhaps 20, 30 years hence. But, at the end of the day, we've got clients, I think, that still need their hands holding during the transaction, if nothing else. And it's not, but the conveyancing process is relatively simple, isn't it? But that's not what we are as conveyancers are there to do. We're there to spot the unusual, the tricky, the high risk, the issues, and make sure clients are aware of them. Oh yeah, Verify 365. I've seen that. Thanks for that. WB. Yeah. Okay. And I'm familiar with that product, and a lot of firms use it, and they seem very happy with it, which is good. Okay. Before I talk about payment diversion forward, I was just chatting to my friend Robert Kelly from Stewart Title before we started today. Hi, Robert. If you could put your microphone on, that would be great. Robert, we were talking about what Stewart Title is about and what it's up to, and you were discussing or mentioning to me something that I think would be really useful for attendees today. Can you just explain to everyone about this sort of facility, sort of for combining defective title product?
Yes, certainly. Already on Solution, there are certain bundled up mixed risks on there, which include a discount, and you can also mix risk yourself. What we're working on at the moment and should be on the system by hopefully the second quarter is that where you combine risks on one property, there will be a discount for the second and third and subsequent policies. Because a lot of the work is done already in the system. So whilst obviously we're not encouraging people to take out policies they don't need, as part of making it easier for you and also making it easier for us, because if you're on the system, then John is freed up to be doing some more taxing work. There will be a benefit there to combine them. It does put you really in control of those cases where if you're looking for a fairly standard risk, a transactional one, but there's also a specific title defect, you can combine them both on the one policy and get a discount there for your client.
Right, and that's now sort of devised, as it were. It just needs implementing and putting onto your system. Yeah.
It is like all these things. IT departments and PD departments have a different timescale to the rest of us. But yes, the hard work has been done behind it. It's obviously, as you appreciate, there's a lot of quite bizarre matrices behind it, combining the prices. That's now being done. It's merely getting onto the system, and most importantly, making sure it works once we turn it on.
Okay. And your online platform, as it were, that is that available to Scottish lawyers as well as
it is
else?
Indeed, yes. It's available. There are tags on there for England, Wales, Scotland, and Northern Ireland, so it's available to everyone. And Liz can come and do some training with you to show you how to use it. Because all these systems, it's designed to be easy to use, but there's always a few little tricks in there that you probably need someone to point you to, and Liz is very happy to come and do that training for you.
Fantastic. And I think you were mentioning, Robert, that John is happy to talk to firms about compliance issues in Scotland.
Yeah, excellent. Yes, John has excellent experience and history on these things and on Scottish law generally. So again, we're quite happy to come and do those for you, or if you're having any training days or involved with any law societies or groups that require training, then we can come along and support you with those.
Brilliant. That's fantastic. Thanks for that, Robert. The last thing I wanted to talk about was just payment diversion fraud and sophisticated fraudsters getting into systems, hacking systems, etc., and notifying clients of changes to client account or where funds are to be dispatched, etc. Just still a nightmare from talking to people. I was talking to someone at the National Crime Agency that was saying that sort of payment diversion fraud, hacking of systems, etc., is sort of booming, which is terrifying, isn't it? And no matter how many platforms, how many systems you have to prevent it, it's the hackers, etc., and these bright young things, if we can call them that, are capable of sort of intercepting, diving into systems and carrying out all manner of sort of mayhem as a consequence. So please be careful with regard to that. Okay, we've got 4 or 5 minutes left before we finish. A few things. First of all, we've got a Scottish conference that's hopefully taking place in March. We've just about got things finalised with regard to that. Anyone interested will send details out to you concerning that. Second thing is, at some stage over probably Easter time or somewhere around about there, I'm intending to come up and do a little tour of Scotland. So if anyone wants to have a meet and have a chat about what we're doing with the forum, what you'd like us to do with the forum, happy to do that and happy to come and talk to you about it. Got loads of interesting speakers lined up for the year to come along and do presentations. If you've got anyone that you'd like to come along, so we're talking about PSS today, or indeed anyone else, more than happy for them to come along to explain what they do. I don't like the idea of a sort of it being too salesy, as it were, but enlightening conveyancers, highlighting product benefits of product, etc., really useful. If you come across any case law or any issues or any particular problems with regard to title, again, happy to look at that and to talk about that too, and indeed anything else. Because as we started this afternoon, the purpose of the forum is to give you a facility to use. And as I say, I'm happy to throw out topics that I think of interest, but at the end of the day, I'm a pretty sad old stick, and what I think is of interest or concern to you may be completely off beam. Much rather you say to me, Ian, can we talk about this issue related to missives, or can we talk about this in connection with coal mining, or have you seen this product, or have you seen this problem, with regard to the standardization group precedents, looking at the templates and saying, well, we've chopped them around a bit, or we've done this or done that. All that sort of thing I find really exciting. Before I finish today, there is a book I was just about to order. And it's a book on car parking, and the guy that wrote the book is a KC who is dual qualified England and Scotland, and bless him, there's a section on issues related to car parking in Scotland, not just Moncrief and Jameson, all manner of different things. What I'm going to do is I'm going to buy it and read it, and I might see if he can come along at some point, because he's got some really interesting ideas about issues relating to car parking in Scotland. And he was the barrister that was involved in the case of Moncrief and Jameson when it went to the House of Lords. So that would be interesting. We have lots of connections with counsel and advocates in Scotland. And again, if there's anyone in particular of counsel or advocates that you've used in Scotland on matters, and you think they would be interesting to have a chat with, send me the details and I'll happily get them to come along. Before we finish then, a few things. First of all, if you're interested in our conference, let me know that email address. We'll add you to the email address in our mailing list and we'll keep you informed. If you have any questions or queries about anything that we've discussed today, that's my email address as well. More than welcome to ping me an email whenever you wish. And again, don't just think I've got to think about topics during the presentation. If something crosses your desk, if something sort of annoys you, as it were, let me know as it and when it annoys you, and we can incorporate it into our next webinar and our next forum. But I always do enjoy these forums, to be honest with you. I really want, first of all, to thank you all for coming along today. I appreciate how busy everyone is. Massive thank you to our contributors today. Really kind for you to share information about PSS, information about standardization documents, etc., conditions and all that goes with it. Really useful. Massive thank you to John and Liz and Robert from Stewart Title for coming along today. And all that's left for me to do is to thank you all, ask you all to stay safe. I don't know what you find. I think, well, I haven't talked about this because I haven't had time to talk about it's really, really busy, isn't it? It's crazy. Normally January, you think, right, there'll be a nice sort of gradual introduction to the year and it'll be nice and steady and quiet. I found immediately after Holiday, bang, we're in, and it was full systems go. I mean, I was training firms on the 6th of January. Normally, the first 2 weeks of January, no one would even ever think about doing training work, but we were doing some. So yeah, I think we're in for a busy year. Okay, on that note, folks, thank you so much for coming along today. Really enjoyed it. Do contact Stewart Title if you have any questions or queries concerning product. Contact me, Alison. Always a pleasure, my friend. Thank you for coming along. Take care, everyone. Speak soon, and thanks very much. Bye-bye. Thank you, Debbie. Thanks, everyone. Thanks, Diane. Speak soon. Bye-bye.